when you file a bail application in the Sessions Court in this country, in between the time period of you having filed the application and by the time it is listed before the Sessions Court judge, there are two very, very crucial steps that you need to ensure have taken place so that your hearing goes smoothly and you are able to get the relief. When you are filing a bail application as a lawyer, every hour is crucial because every hour is there is this possibility, if the person is outside jail, if it is an anticipatory bail application, that the police will catch up with the person and arrest this accused person. If the person is inside custody, it goes without saying, every hour that a person spends in jail is, especially in a false case, is the biggest travesty of justice. So every hour, every day is very, very crucial when there is a person either inside jail or apprehending arrest. And therefore, these two steps are very crucial to ensure that there is no delay of, in some occasions, hours, and in some occasions of days, in you getting the relief that you as a lawyer, your client is justified or your client deserves. First step, to definitely save a good number of hours and sometimes 1 or 2 days as well. Once you have filed your bail application, you are told by the registry that this matter is now going to be listed before this XYZ judge in the Sessions Court. The difficulty is that if you believe that the matter will show up in the list and that confidently you will go and you will be able to argue the matter, you are mistaken. What's going to happen is you will find out when you approach the court that maybe your matter is not there in the cause list, which is the list of matters for the day. The matter might not be there in the cause list at all. And even if it is there in the cause list, the second hurdle is that the file might not have reached from the filing counter to the particular court. And this is a very, very regular problem. This is something that as a new lawyer you will face on a very, very regular basis. And of course, if you're a person who is watching this video who is not a lawyer, who has maybe a bail application listed, or who you're planning to file that bail application before a court, if your lawyer does not take care of this, you are the one who's going to suffer the consequences. So what happens is you go to the court, you find out that the file is not there. Then you spend a couple of hours going back and forth between the filing counter and between the courtroom, and you ensure that the file finally reaches the courtroom of the judge, and then the judge is able to take up the matter. So the moment the matter is filed and when they say that this particular judge, the matter will be listed, the best thing to do would be to go to the reader of that particular court, and not the reader. The reader is, just as a little bit of background, the reader is the person who actually hands over the files to the judge. But if it is a fresh filing, the matter will first come to the Elmad of the court. So the first thing you do is you go to the Elmad of the court and you explain to him that this matter is filed, that this will be listed. So the Elmad will keep it in the back of his head. You maybe take the Elmad's phone number as well and call him up maybe a day prior and confirm whether that file has been received or not, whether it has been marked in the cause list or not. And if it is not done, you can maybe ask him to call up the filing counter and ask for the file. If he can't do that, you can at least go or maybe send someone and ensure that the file comes to the courtroom and is received by the Elmad. And then, of course, once the file is received with the Elmad, then it is not a problem. Then even if the file is not there at the dais of the judge, you just need to circle back to the Elmad, ask him to give the file, and he will immediately supply the file at that moment. The second thing, which will definitely ensure that you cannot get the relief that very day, the day the matter is listed before the court, and there will be a delay of minimum 1, 2, 3, maybe a week, 1, 2, 3 days, maybe a week, maybe even 10 days, is if you do not supply an advance copy of your bail application to the investigating officer. A lot of times, I personally, there have been several occasions where I am extremely angry at the investigating officer when I'm representing an accused person. Of course, because of the because of the biased, unfair investigation that is taking place. The efforts of the investigating officer to, get a bribe maybe, or has already taken a bribe from the other side and is trying to pressurize this person to settle the matter, or maybe to, come and arrest the person. So I feel very, very angry. I do not want to have any contact with the investigating officer. That is a very big no. That's a very big mistake that you can do for your case, for your clients. What you need to do instead is to ensure coordination with the investigating officer. I am not saying that you go and bribe the investigating officer. All I'm saying is when I say coordination, I mean calling up the investigating officer, telling him yourself that my matter is now listed for day after tomorrow or tomorrow at so and so time before this judge. Because if you don't tell the investigating officer, now normally what happens is that the filing counter sends the file to the court. Now the court every court is connected with the police station that it has jurisdiction over, or that's the magistrate's court. Here, if it's an anticipatory bail application, then it will be the sessions court. Each court connects itself to the police station concerned through a person who is called a Naib court, Naib, Naib court. That's at least what happens in Delhi. There might be different terminologies used in different states. At least in Delhi, there's the reader. I think the reader is common everywhere, or sometimes also called the court master. There is also the Ahmad, which I've seen at least in Delhi, Haryana and UP. And then there is the Naib court. Again, Delhi, Haryana, UP I know about. I don't know about other states, what they're called. So the court will direct the Naib court. The judge's courtroom will give a copy to the Naib court and say, you supply to the investigating officer, and then the investigating officer will file a status report on the day of the hearing, maybe a day prior, or maybe he will seek some more time to file the status report. However, if just in case, and this happens very, very often, in fact, not just in case, it happens very often, that you will find out that the Naib court was maybe not given the file in the first place, in the first instance, because the file was not received by the filing counter and, could not forward it, or received it, but because of all that goes on in the court, they forget and sometimes even deliberately they say, why do I even bother? I'll give it on the next date maybe, or maybe I'll give it tomorrow. And so what happens is the investigating officer does not know that your bail application is listed. Some people think that it is a good thing that the investigating officer does not know. So he will not be able to be present to oppose the bail application. That's a big mistake. Why? Because of the fact that in the absence of the investigating officer, merely on the pleadings made by you in your bail application, the sessions court judge or the magistrate or whoever it is, the judge in the district courts, is not going to pass any orders. Now, there is, of course, this other aspect when it's an anticipatory bail application, the aspect of interim protection. And you might say, my lord, all right, my lord may issue notice to the investigating officer, but at least I may be given interim protection. From my experience, I can say that on most occasions, if the investigating officer is not there, in the absence of the investigating officer, the court is very, very apprehensive in even granting interim protection, even if for a day or two. What the judge will do is the judge will say, all right, I'm keeping the matter for tomorrow or day after tomorrow, and I am calling the investigating officer, which means that 2 days, 2 very, very valuable days of the client are gone when the investigating officer is not there, the matter is adjourned, and the court is also not granting any interim protection to the accused applicant person. And therefore, again, at minimum of 1, maybe even 2 or 3 days are wasted right there as well. So these are 2 of the situations which you need to be mindful of. You need to be careful. If you just take these 2 simple steps, it will perhaps take you 5 or 10 minutes. You send an advance copy of your bail application on WhatsApp to the investigating officer. You call up the investigating officer and tell him that on this particular date, in this particular courtroom, we have our matter listed. I request you to show up there at 10 a.m., 10:30 a.m., whatever the time may be. This saves you a lot of time and effort, but more importantly, those crucial hours and those crucial days when your client is suffering jail or is afraid of arrest, you could save him those crucial few hours and days.